noises. Does somebody have a fan on?
Oh, yeah.
Yeah. Mr. Reyna, you need to remove your hat. You need to park your car. Okay, Mr. Reyna.
Yes, ma'am.
Okay, I've told you once that you're in court, so I'm not sure why you're taking us traveling around with you.
All right, I'm sitting down now. I'm sitting here waiting for.
Yes, you shouldn't be driving. You shouldn't be walking around, taking us into stores with you or anything else. You are in court.
Okay. Go!
You hand me my spinning box?
Now go.
Okay, and so we are going on the record in the matter of the city of Riverview versus William Hinala, 2443B. And counsel, your appearance, please.
For Your Honor, P73006 on behalf of the defendant.
All right, thank you. And Mr. Hinala, your name, please, for the record.
William Hinala.
All right, and so today's the date scheduled for sentencing on your client's plea to an amended charge of failed to report an accident that had been reduced from leaving the scene of an accident. And counsel, did you have an opportunity to review the report and recommendation?
Yes, Your Honor. I reviewed the pre-sentence investigation with my client this morning. There were two minor corrections. The first was the sentencing date is listed as 2/9/24. The second is that my client's age is listed as 71 years old. He is actually 76 years old. Beyond that, there are no additional additions, deletions, or corrections.
Okay. I did have a question. So, Mr. Hinala, in reading the police report and in reading your statement to probation, it appears as though you're unsure as to what you hit.
That's correct.
Okay. There's a bit of a difference between hitting something in the median and hitting a car that's parked.
There were no cars there.
Your Honor, the car in this case, after reading the report, I don't believe was parked. I believe it was in motion. But be that as it may, my client realized that, you know, either way, if he had hit something, which he pled no contest to, if he had hit something, he would have been required to report it either way. So,
all right. And so, counsel, as to the recommendation.
yes, Your Honor. After reviewing the recommendation, my client is in agreement with the terms with the recommendations of the probation department. Request fines and costs only, and leave it at that, I suppose.
All right. I don't know. We don't have Edwin read that here, checked in virtually or in person in the courtroom. And so the court does find that there is not reasonable grounds to depart from MCL 769.5A. The court is going to order the following. I believe the fine for failed to report is $100, $100 screening cost of prosecution, $300, crime victim assessment fee of $75, justice system assessment fee of $50, which will have $625. Do you have that to pay today, sir?
You pay $625 today?
Yes.
Okay, just have a seat in the lobby and somebody will be with you shortly, okay?
Thank you.
Thank you, Your Honor.
Have a good day. We're going to be off the record. All right, we are on the record in the matter of Carrie Hernandez, 231248A. And counsel, your appearance, please.
Yes, Your Honor. Edward Holmberg on behalf of the defendant. Your Honor, after reviewing the allegations with the defendant, she is prepared to enter a guilty that she did test positive twice for cocaine. Once on once on March 8th. I believe the other one was on the 17th of February, and that she also tested marijuana on the 8th as well. Is that correct, ma'am?
That is correct.
Okay, and I did tell you have a right to a hearing and what the burden of proof is, and you decided to waive that hearing and plead guilty, correct?
Correct.
As to those two allegations, ma'am, which are also technical violations 1 and 2, how do you plead?
Guilty.
And specifically in this matter, the recommendation is for you to continue and complete all terms of probation, revoke under advisement status, $50 probation violation fee, outpatient substance use counseling, and 10 days jail. Do you understand that?
I do.
Knowing all that, do you still want to continue with your plea?
Yes, I do, Your Honor.
Counsel, if you can please volunteer your client.
Yes, on the dates given, which were the the 17th of February and the 8th of March, on those dates, did you ingest or use?
I did.
Okay, and obviously you knew that you were not supposed to do that as part of your probation, correct?
Yes.
I'm satisfied, Your Honor.
As well as the, correct?
As far as I apologize, yes.
All right, and so ma'am, so the court does find that the plea is knowing, voluntary, and factually accurate. A probation violation is found based upon defendant's plea of guilty. Technical violation number 1 and 2 will enter, and counsel adds to the recommendation.
We would ask that we understand what the recommendation is, Your Honor. We would ask that you convert the jail time to workforce days or community service instead of our serving the 10 days in jail.
Okay, well, ma'am, let me see here. You are on probation for possession of controlled substance. You have prior convictions as well. And now here you are on probation, and you have 2 more of the same.
Your Honor, the prior convictions are well over 10 years old.
Okay, that tells me that you've had a concerning issue then for quite a while.
I have. I am in counseling, Your Honor. I did lose a daughter 4 years ago. I deal with a lot of things. I understand that drugs is not the way to go. I was working in a bar. I quit. I'm trying to fix my life the best I can. I was young. I had children young. I went down a bad road. I made a lot of mistakes, but I am trying to fix myself. I am in counseling. I do see a psychiatrist. I am open and honest. I'm trying, Your Honor.
Have you cleared
It's
up?
been a hard road losing a young child.
I don't disagree, ma'am. I don't disagree. I don't pretend to understand, but I don't disagree with you.
My daughter was very ill, and it was a lifelong challenge. And I lost her 4 years ago. And all I could say is, it won't happen again. I'm doing my best.
Ma'am, I can understand that. However, there are orders of the court that you're not following.
I
Not just
understand.
one, but twice.
I understand. Like I said, I was working in a bar. It was a bad atmosphere for me. I quit it. I'm helping a 91-year-old man now. I'm just doing the best that I can in my life.
Okay, have you cleared up your warrant out of, I believe it was Allen Park?
I'm trying to pay you first. I live on disability, Your Honor. I have a house. I struggle.
Well, let me just clarify, ma'am. So you said you're paying you, meaning the court, not me directly. I just want to clarify that for the record. Whoops.
All I could tell you is that I'm trying to change my atmosphere in my life. I live on $1,300 a month. I own a home and I live by myself. It's not easy to pay these bills. So I'm trying to pay Wyandotte, and then I plan to take care of Allen Park. Allen Park was a parking violation. I don't want that on me. I want to clear it up. I'm going to be 58 years old. I don't want to live like this any longer.
All right. Well, the court's going to assist you in that regard, ma'am, because the court's going to order you to continue and complete all terms of probation. The court's going to revoke your under advisement status, $50 probation violation fee. You are to participate in outpatient substance use counseling, and the court's going to order 10 days jail. I'm hopeful that by serving your 10 days jail, ma'am, you are going to, that will help get you on the maintaining the correct path.
Well, probably not, but if that's what you choose. So do I go turn myself into Wyandotte?
You will email into Ms. Shine, and she'll give you instructions as to how to report. So
I don't know how to do all that email. I'm old school, Your Honor. I barely learned how to do Zoom.
Okay, ma'am. You can certainly go in and speak with her. That's fine. She'll give you the reporting instructions. I was going to give you until tomorrow to report, unless you want to just report today.
Yeah, I have animals. I don't know what I'm going to do with them. I mean, I guess they'll sit in the house. I don't know what to do. I don't have anybody. My daughter that passed was the only one I had. So can you recommend what I do with these animals? I have 2.
I don't know what kind of animals you have, ma'am.
Shut up, Henry.
Well, it sounds though you have a dog.
Yeah, I have 2 dogs. Yes.
Okay. All right. Well, I don't know, ma'am. You may want to speak to a neighbor. I don't know. I'm going to order that And so please go on in and shine before 11 o'clock today.
Okay, I'm sorry, I didn't hear you.
Please go in and speak to Ms. Shine before 11 o'clock.
Tomorrow morning
No, speak to her today by
before
11.
11?
Yes, and she'll give you all of your reporting instructions.
Okay. And then I have to contact the elderly man that I care for and let him know that I will not be available.
Okay,
Okay, thank you, Your Honor.
have a good day.
So I go to jail. I'm going to jail. Wow.
Okay, Your Honor, Edward Holmberg on behalf of the defendant. Your Honor, today was the date time for a violation of probation in this matter, and I believe also a bond violation. That being said, the defendant will make an admission that on the 8th of March, he did fail to test, and on the March 25th, he did not meet with his probation officer as he was required to, but he does have an explanation for that date. Your Honor, I did go over what the recommendations are from the probation department. He's aware of those. He's also aware that he'll be, what the burden of proof is, what the probation department would have to prove at a hearing, and he is waiving his right to that hearing. Is that correct, sir?
Yes, sir.
Okay, and so Mr. Reyna, your name for the record, please.
Christopher Reyna.
Okay, and so the court will note that there were two issues today. One is a bond violation because Mr. Reyna was out on bond and on February 27th was ordered to test. And so he tested on February 27th and tested positive for alcohol and marijuana. And then subsequent to that, on March 25th, he failed to appear for probation and he failed to appear for drug testing on March 8th. And so those two are listed as probation violations.
Correct.
The February 27th matter is listed as a bond violation because your client tested that day, but he was still on bond, and because of the presumed consumption during the bond period, that's why it's a bond violation.
Okay, understood about Your Honor.
So, Mr. Reyna, please raise your right hand.
Yes, ma'am. Yes, Your Honor.
All right, thank you. And so, sir, you heard what your attorney stated, correct?
Yes, Your Honor.
All right, and as to the bond violation, how do you plead?
Is it for both of those charges, or is that for?
Basically, that you still had alcohol and marijuana in your system while you were on bonds. You said you would have the marijuana, so you were going to plead guilty to that. Remember?
Yes, sir. Yes. Oh, yes, sir.
So you are pleading guilty, correct?
Yes, pleading guilty. Yes, I thought I would be all right because I wasn't on probation yet, but I wasn't on bond, I guess. So yes, Your Honor.
Okay, and so, sir, as to the allegations for the bond violation, how do you plead? Guilty or not guilty?
For the dropping dirty, or for not talking to the probation officer, or for missing the drug test, or
For all of them.
Well, I had an explanation because
Yeah, you're going to plead guilty with an explanation to the missing on the 25th. We went over that, remember? So plead guilty like you said you were going to do.
Absolutely, yes, I'm guilty, Your Honor. Yes, yes.
Okay, and then we'll offer that explanation to the judge when the time comes.
Absolutely. Absolutely.
Okay. All right, and so
Would it help if I maybe did the voir dire, Your Honor?
you can, yes.
Okay, so on March 8th, while you were on order to test for drug and alcohol testing, you did miss that date. Is that correct, sir?
Correct, sir.
Okay, and then on the 25th of March, you were also supposed to go see your probation officer. Is that correct?
That is correct.
And you did
No,
not
I'm supposed to call her.
just let me finish. You didn't get this. You did not call or keep in contact with her like you were supposed to, correct?
Yes, I did.
And you knew you were supposed to see her that day, correct?
Yes, I called her.
Okay. Now, there was a reason why you didn't get to see her that day. Is that correct?
Yes.
You did call her, and you did not respond, correct?
Yes, I called her. I didn't get a response, and then I had called her the day prior, and she told me that she had seen that I had tried to reach out to her, but she had already put the violation in. So yes.
Oh, here we go. Okay. And then as you heard on the 7th, while you were on bond, you had still used, still had tested positive for marijuana. Is that correct, and alcohol?
Yes, sir.
Okay. And you, as you make these admissions, you know that by making these admissions, you've waived your right to a hearing. You understand that, correct?
Yes, sir.
And no one's made you do this. No one's promised you anything. Your own free will, right?
Yes, sir.
Okay. I'm satisfied.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate as to both the probation violations and the bond violations. And as the probation violation, that will be technical violations 1 and 2. Counsel, as to the recommendation,
We understand the recommendations, Your Honor. We would just ask that the 10 days that's recommended he be allowed to serve that with a either workforce or community service of some sort, or be held in abeyance. The gentleman, the defendant, did try to reach his probation officer like he was supposed to. He just unfortunately didn't do it on the day he was supposed to. He did take responsibility for those the missed tests. He understands that was a slight on his part, but again, he's tested negative every time since. I believe from the tests I've looked at that were provided to me. Prior to the 7th, he was on bond, and he did realize the marijuana, I think, was residual in his system. I believe the number should be going down at this point. So we would ask that you just allow him to do those 10 days, either, like I said, on community service or by tether or on some other way.
so if you were to test today, what's in your system?
Nothing.
Because the other concerning part is that even while out on bond, you're testing positive for alcohol, for marijuana.
Yes.
That was on the 27th, my sentencing date, and I didn't know, I just assumed I wasn't on probation yet, so I had time to get my system clear. I might have had a drink of alcohol, a day or two prior, before the court, but
Sir, this court ordered you on January 30th not to possess or consume any alcohol or drugs unless prescribed. At the date
I misunderstood it, then I know you had put me on probation. I just feel, I'm bond. I just didn't know like the implications of the probation were attacked.
So, sir, what is it you did? You went out after court and you went and had a drink before you started probation? I just don't understand.
No, I'm saying, and you saying I was put on probation in January. I'm saying
No, that isn't what I said. That's not what I said. I said,
no, not probation, but bond.
As a condition of bond, this court ordered you not to possess or consume any alcohol or drugs unless prescribed. That was on January 30th.
Correct.
Right.
I'm saying, but before, I'll say from that day to the 27th, I might have had a drink or two before that day, but I'm saying I didn't just go out and start drinking. I didn't go out and start smoking either.
I understand that.
Could have been in my system.
I understand that. What you stated that you did is you figured you'd have one last hurrah, so to speak, before you were on probation.
I felt like I had a beer or something before I got on probation, not remembering or understanding the terms of bonds. Yes, correct, Your Honor.
Okay, here's what the court's going to do. As to the probation violation, the court's going to order you to continue to complete all terms of probation. You're going to pay a $50 probation violation fee. The court's going to order 10 days jail. I'm going to suspend that jail. Okay? We're going to do a jail review.
Thank you, Your Honor.
We'll do a jail review we'll do June 11th at 10 a.m. And the court's going to also order on the bond violation 5 days jail suspended with a jail review on June 11th at 10 a.m. Any questions?
No, Your Honor. Thank you very much. That was very lenient of you.
And sir,
Yes, Your Honor.
stop over probation. Somebody will be with you shortly. And
Thank you.
that's your shot there, sir.
I'm sorry, Your Honor.
That is your that's your shot. This is your shot to show the court that was a one-off.
Absolutely, Your Honor.
All right. Have a good day.
Probation?
It's off of probation, yes.
Thank you, Your Honor. Have a blessed evening.
All right, you as well. All right, these are the matters of Raymond Rasberry. This is 232176 and 232118. And Mr. Rasberry, your name for the record, please.
Benedict Rasberry.
I'm sorry, can you please repeat that?
Raymond Benedict Rasberry.
All right, and counsel, your appearance, please.
Yes, Your Honor, Edward Holmberg on behalf of the defendant. Your Honor, today's date time for a violation of probation here. We're asking for an adjournment in this matter. The defendant has, he believes he was initially represented by Mr. Bolahanis. He'd like to have the opportunity to hire and have Mr. Bolahanis represent him again. He did contact Mr. Bolahanis. Mr. Bolahanis was previously engaged in another matter, I believe it's circuit court, so he couldn't be here. So we're just asking for a short adjournment.
So, Mr. Rasberry, when did you retain Mr. Bolahanis?
Started as I learned of everything in the communication I had. Remember, Natalie was out for 3 months. I was talking back and forth with people.
No, sir. Pause. You received notice of this violation on March 25th. My question to you is, when did you retain Mr. Bolahanis for these matters?
Yesterday, when I found out everything that was going on. I tried to ask questions many times, and I keep stating I'm a very respectful person, and you know that. Everybody tells me not to say nothing, but every time I don't say nothing, I end up getting misrepresented. And I'm not a bad person. I keep getting pushed to the side. My dad come here with my mom. I try to ask to say something. I've been here many times trying to ask and say something. If I would have known what was going on, I would have stated clearly, Bolahanis on the 25th exactly. I did not understand what the detail of it was. And I stated clearly that I would have had Bolahanis and the guy that represented me on the first time, who works with Bolahanis in the same office. Since I'm learning everything, I tried to call him many times to state exactly that first time I talked to you, what exactly had happened. And for some reason, I keep getting put that if you say something, you can get way more done to your life. And the part of it is, I've tried to ask to speak to somebody on the side, and they keep saying, Bolahanis says, don't say nothing. The point of it is that when you have a closed head injury like I had back here years ago, and all the stuff that went on, you have seizures. The point was, when the first time that you see me, that's what I was taken in for, because I had a seizure and I was taken in for protection. But then I end up down in downtown Detroit for 7 days, told that I'm nothing, I have no existence. And I find out after 4.5 months of heard the testimony.
Okay.
That I did a good job representing what I was doing. But for some reason, I'm not clearly under the guidance that Bolahanis, first thing he told me is now that I understand where you're coming from, he keeps telling me you never want to say nothing in court, because guess what? They'll give you a stricter sentence.
Okay, well,
Basically,
hold on, sir.
okay, I'll stop talking then. That's fine. You
I
got
understand you have a
it.
lot you want to say, but what I'm going to state is, since you've indicated that you retained Mr. Bolahanis,
Yes,
the court's going to enter plea of not guilty for purposes of the probation violation arraignment today. Schedule these matters for hearing April 16th at 10:30 a.m.
good, thank you.
And the court's going to order the following bond on these matters. $5,000 personal bond. The court's going to order an alcohol tether. You are currently on probation for public intoxication and operating while visibly impaired. And then it's alleged that you've tested positive for alcohol. And so the court's going to order you to have an alcohol tether, sir. So please stop over at probation and they will get you that information, sir.
Okay, thank you very much. You have a good day.
All right, you as well. And so we are on the record then in the matter of Josie Franco, 152011.
Morning, Your Honor. Good morning, Your Honor. Attorney Christopher Smith, P number 83547, representing Ms. Franco, who's standing to my right.
All right, thank you. And Ms. Franco, your name, please.
Josie Christine Franco.
All right. And today is the date scheduled for the probation violation hearing. And, counsel?
Yes, Your Honor, we'd like to enter a plea of guilty. There's two counts. She failed to comply with the order in 2018, the report, and she failed to pay the money as well.
All right, and so, yes, this matter, your client had originally pled not guilty on March 19th. We set it for a hearing today. And so, ma'am, please raise your right hand.
I do.
All right, thank you. All right, as to the allegations, you failed to appear for probation, failed to pay. How do you plead?
Guilty.
Specifically, the recommendation here for probation be revoked, matter closed without improvement, and 45 days jail, $50 probation violation fee.
Well, we would like to explain why I don't think that you should follow that report.
Counsel, I understand. We'll get to that. I just want to make sure that she understands what the recommendation is.
Yes, you understand what the recommendation is?
All right, and you understand the court can either follow that in whole, in part, or deviate completely. Do you understand that, ma'am?
Yes.
All right, and knowing all that, do you want to continue with your plea in this manner?
Yes.
All right, and counsel, if you can please ready your client.
Yes, on June 12th of 2018, did you fail to report to probation?
Yes.
And you didn't have permission to do that, did you?
No.
And you understood that you had a balance of $900 that you were ordered to pay in your plea to larceny on this case?
Correct.
And did you pay the $900?
No.
And you haven't, and you weren't, the court didn't tell you you didn't have to pay, did you?
Yes.
So right, you didn't pay. So, is the court satisfied with that?
Well, I couldn't hear what her answer was. You said the court didn't tell you to pay.
The court didn't tell you that you didn't have to pay the $900. You understood that you had to pay the $900, and you didn't pay the $900, did you?
Yes, correct. I made a payment yesterday and I can make a payment today.
Okay, and so the court does find the plea as knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation, and counsel asks for the recommendation.
So, like I just stated, this case was back in 2018, and so a lot has changed in 6 years. Ms. Franco was not sober when this case occurred, and so she got into a lot of trouble in a few different courts. But her attitude has completely changed. She, she is living with her daughter, and she is on the up and up now. She has a job, and she did turn herself in on all the cases that she had pending. Unfortunately, she did turn herself in Judge Mullins' court in Southgate, and she was given 93 days of contempt for that, and that was just recently in October of 2023 to December of 2023. And so she had a lot of time to reflect there, and then that right after she got out, she turned herself in here, and she paid $100 yesterday toward these fines that she owes, and she has another $100 today. After spending the 93 days in jail in 2023, she had to start back from scratch. But now she has a job, she has a house, she takes care of her daughter who's in college, and if you give her the 45 days that the probation is recommending, she'll be back to square one again. And I think she's learned her lesson. So, we would respectfully ask if you put her on maybe a payment plan. Because she has a job now, she can pay, and she's willing to pay, and she wants to pay. She wants to get this behind her, and maybe set like a review date 6 months in advance. But if the court is inclined to give jail, we would ask that maybe she can do weekends so that, she doesn't lose her job, lose her house, and then, be indigent, really.
All right, so a couple things, counsel. Number one is your client turned herself in on March 19th, so that was about 3 months after she was released from serving her time with the 28th District Court. And so I can understand that there have been a lot of life changes for your client since then, since she was placed on probation in this court. What are the options? If your client clearly isn't probation material, and so then she absconds from probation has a warrant out for her arrest for, what is it, 6 years or so? And what, just walks away with fines and costs after that? I just don't understand.
No, I completely understand. She wasn't sober. She was on drugs, and that led to her life of crime. She has a list of drugs that she is currently on. They're all prescribed. If you were to drug test her today, she wouldn't have anything in her system that would be a red flag that's not prescribed. And she's going to therapy too. So I get that. What she did was wrong. She understands that. She knew she had to report to probation. But she didn't do it. But like I said, Judge Mullins gave her 93 days, and then after she picked herself back up off her feet, now she's here in front of you. She's remorseful, and I think that it would be really tragic for her just to spend that 45 days straight, because then she'll be out on the street, and then she might relapse because of that. But if the court is inclined to punish her, which she might need some more punishment, if we could just do some weekends in jail, then she'd have more time to reflect. But at least she wouldn't lose her job, and she can pay this off.
I love the idea of weekend jail, but after COVID, Wayne County Jail hasn't resumed weekend jail, as far as I'm concerned, or as far as I'm aware. So here's what the court's going to do. Where's your client working?
She is working at landscaping, and that's a Monday through Friday job. But I think it's like, are you a receptionist?
Yes.
Receptionist.
Advocate, reception.
But I guess, we wouldn't be opposed to community service either. I mean,
I'm the media team at my church. I clean there. I do all the streamline. I take Narcotics Anonymous classes. I take NA classes there. I'm in therapy.
Right. So I don't know if the court. I tried to get the file from the probation department before this. But she does have the correct.
Here's what I'm going to do. I'm not diminishing anything that you've done, ma'am, and the work that you've been putting in. What I'm going to do is I'm going to do 45 days jail. I'll give you credit for the time you've already served, because there was an attempt for a plea by mail to have been done. So I'll give you credit for those 45 days that you served there with the Southgate case as well. And so I show a balance. You have another payment due, ma'am, on May 8th.
Yes, Your Honor, May the 8th. But like I said, she does have $100 a day, and if you could, I think is prepared to pay $200 a month going forward, because she has this job now.
Please stop at the window, and somebody will be with you shortly, okay, ma'am? Regarding your payment.
Thank you.
Good luck to you, ma'am.
Thank you.
Thank you so much, Your Honor.
You're welcome. So we are on the record in the matter of Logan Richardson, 23204. Mr. Richardson, you need to please unmute and start your camera. And counsel?
Thank you. Sean Head appearing again on behalf of Logan Richardson, who is present with us on Zoom.
Which he appears to be outside, but I can hear him. Okay, Mr. Richardson, this is not going to work.
What was that?
This is not going to work. There's too much background noise, and it's hard to hear.
Yeah, I'm trying to walk in for you, ma'am. I apologize.
Okay, just a moment. Let's go off the record while you're doing it. Off the record.
Okay. Put it on mute, though, so you don't have that background noise.
Sean Head again appearing on behalf of Mr. Richardson. Your Honor, today's date and time set for a probation violation hearing. I have received the notice of the violation. I've not received any recommendation or anything from probation. I'm not sure if there was one.
The recommendation is to continue and complete all terms of probation, extend probation for 6 months, continue under advisement status, $50 probation violation fee, must test at court-approved facility, 10 days jail, suspended with a review.
Okay, and I'm sorry, I missed the second thing that you said. Extend jail by 6 months, and then I didn't hear after that.
Extend probation for 6 months, continue under advisement status, probation violation fee of $50, must have a court-approved facility, serve 10 days jail.
Get out the.
Mr. Richardson, I am going to say that my patience with you is a little bit done. You're not muted, so whoever you're talking to is interrupting the record.
It's like that. You just stare down on them, let the eyes do the work. Your mouth might be saying, hey, we cool, but your eyes are like, no, we not.
And it doesn't appear as though it's even a good connection. Hey, Council, here's what I'm going to do. I'm going to adjourn this to next week, and it's going to be in person.
Your Honor, I think he's available now. I think it's where it does appear to be a better connection.
Okay.
Well, I'm not going to continue with. For some reason, he took him 2 extra hours to log in. Then having some connection issues. So let's just adjourn this to next week.
I've been logged, Your Honor.
Sir, you have not been logged in. I'm the one that manages the waiting room, and everything else was Zoom. You have not been in the waiting room. At one point, you were in the waiting room and your attorney was also in the waiting room, and then your attorney was there by himself. He's been here for a while. The only time you were in the waiting room is once I let you in, after the first time I saw you there. So that's it. So, Council, does April 16th work?
Yeah, yes, Your Honor, I can do that in the morning.
Okay, 9 o'clock?
Yes, Your Honor.
All right, the court's going to order a $5,000 personal bond. Mr. Richardson, we'll see you next Tuesday in person.
So it'll be in person?
Yes, at the courtroom. Yes.
Okay.
Okay? All right, thank you.
Thank you, Your Honor.
I'm going to enter a plea of not guilty for purposes of the arraignment today, okay?
Okay, thank you, Judge.
All right, have a good day. Okay, we're on the record in the matter of Zeal Credit Union versus Theodore Sello, 231910. And, okay, Mr. Sello, I need you to turn the fan completely off, please.
I did.
Okay, yes, now I don't hear that anymore. Okay, an appearance for the plaintiff, please.
Good morning, Your Honor. Christopher Sosson, spelled S-O-S-S-O-N-G, P593838, appearing on behalf of plaintiff.
Okay.
Good morning, Your Honor. John Devanchek on behalf of the defendant, who is also present.
All right, thank you. And Mr. Sello, your name, please, for the record.
Theodore Sello Jr.
Okay, and so I did review, I know that we had adjourned this matter. We had some my file issues last time. And so that was, I believe, on March 19th. And so court wanted to review the plaintiff's response as well. And so here's what I'm curious, and I reviewed the case law as well. And I'm having a hard time finding that this is not a deficiency action. So Mr. Sosson, how is it within the statute of limitations based on what appears to be the case law?
Thank you, Your Honor. It is plaintiff's position that this is a loan agreement, Your Honor, not a contract that was entered into by the parties originally for the sale of a good. And therein lies the distinction, the UCC defining a seller pursuant to MCL 440.2103 subsection 1 subsection D as a person who sells or contracts to sell goods. And that's the key distinction here. Plaintiff extended a loan to the defendant, a loan, a service of providing money in exchange for a promise to pay. We don't have a transaction for the sale of goods, hence the application of the UCC and the statute of limitations that's the subject matter of this action pursuant to 440.2725, which states an action for breach of contract for sale must be commenced within 4 years after the cause of action has accrued. And so we also, if we look at as well, as set forth in defendant's own motion, that the official commentary to the UCC makes it clear that contracts for sale are governed by this statute than the general statute for breach of contract. And that's on page 8 of the defendant's motion. And in relevant part, the defendant cites commentary, official commentary, which in relevant part states this article takes sales contracts out of the general laws, limiting the time for commencing contractual actions, and selects a 4-year period as the most appropriate to modern business practice. Again, the key distinction, Your Honor, here is sale of goods. That's not what plaintiff is engaged in the business of doing. This was a direct loan, a contractual agreement to lend money in exchange for the promise of pay. This is not a motor vehicle sales contract, which is what the case that defendant had reference to in support of their argument sets forth. In that particular case, there's no question that the plaintiff in First of America Bank v. Thompson, 217 Mishap 581 case, published opinion in 1996, addressed the assignment of a motor vehicle retail installment sales contract. And so the assignee in that case, Your Honor, First of America Bank, took, pursuant to that motor vehicle retail installment sales contract, what rights the original seller had. In that case, it was clearly right from the outset a transaction for the sale of goods. And so in that case, the court did correctly state that, hey, you take whatever rights the original seller had under that contract. And so correctly, that statute of limitations as set forth by the Court of Appeals is a 4-year, because the original contractual agreement between the parties was one for the sale of goods. This is not. And hence, that's the distinction, Your Honor, as we've argued in our response to plaintiff's motion. That's the distinction, given that this is just a general contract or promise to pay back a loan that was extended to the defendant. It is plaintiff's position, Your Honor, that MCL 600.5807 subsection 8 then applies and sets a 6-year statute of limitations as opposed to the 4-year that governs the sale of goods. And so that is plaintiff's position, Your Honor, that there's the distinction, the sale of goods. This transaction doesn't bring it within the scope of a seller under the UCC, because it's not a contract for the sale of goods, and hence MCL 600.5807 applies. Thank you.
Okay, so before I give Mr. Banchek an opportunity to respond, what I'm going to ask Mr. Sassong is, how did you come up with the dollar amount? Because I see that there's a couple of issues here. Which type of action is it? Which then would then determine which statute of limitations would apply. And I'm trying to confirm, counsel, the amount of the loan or the amount of the claim, because it appears as though at one point there was a $1 amount and now there's an additional dollar amount. So how do you come up with $4,738.91?
That amount, Your Honor, would include interest. The sale occurred, the auction occurred on May 17th, 2018. Excuse me. Let's see here. The vehicle was sold on January 25 of 2018. And as exhibit number 4 indicates, a deficiency balance letter was sent to the defendant on May 17th of 2018, indicating that at that time, after the loan proceeds from the sale of the vehicle were applied, that the deficiency balance at that point was $2,844.73. And so we do come back to the original loan agreement as set forth in exhibit number 1, exhibit number 2, which sets forth that the interest rate, Your Honor, applicable here is 20%. The cost of the credit is a yearly rate, 20%, the annual percentage rate. And hence, Your Honor, we have the ongoing interest that accrues on that balance thereafter pursuant to the contract between the parties, so long as that balance remained unpaid. So the difference that Your Honor is referencing to would be the interest, Your Honor.
And that's interest that's been accruing since January 25th of 2018?
Since the sale of the vehicle, the deficiency balance, that's correct, yes.
And so what about defendant's position that interest cannot accrue on the sale, on a deficiency sale?
Well, plaintiff would again rely on the agreement between the parties that the interest rate is set forth on the loan that was extended to the defendant continues to accrue. While the proceeds from the sale of the vehicle after the auction were applied, we still have the loan agreement itself, which sets forth the interest on the unpaid balance. And so it would be plaintiff's position that clearly as set forth in the agreement, the interest rate would continue to apply on the unpaid balance until there's payment.
Even though it's clear, it appears to be by statute that if the vehicle is sold that you can, and there's a charge off, so to speak, that you can't continue to assess interest?
Yeah, I'm looking for the authority in the defendant's motion that prohibits, and
I reviewed, when I was reviewing this last night, I reviewed that as well. And it's clear, and this is MCL 440.2725 paren 1. I mean, this is specifically deficiency actions from a repossessed motor vehicle are governed by a 4-year statute of limitations. And so
but that all presupposes the court applies, that the court considers this a transaction for the sale of goods. I would argue.
Well, I understand what you're going to argue, but this is exactly a repossession of a motor vehicle that was resold, and it was resold, and there was still a deficient amount that was still due and owing from the loan, correct?
Correct.
Okay, so it appears to be on point, specifically on point. And so you want this court to interpret now with some creativity that this case here, this instant case here, is different than the case law, and that I should then interpret that this is not a contract for sale of goods, but it's a repayment of money loaned to the defendant, which in the case law that Mr. Ivanchik has cited is exactly that. And so is MCL 440.2725.1. So I'm not sure how, and stating that in First America Bank versus Thompson, in Hardin, there was a debt collector that sued the plaintiff on a time-barred debt arising from the financing of an automobile. So just like this case, the complaint purported to assert claims based on breach of contract, open account stated, and or unjust enrichment. The defendant argued that it was not time-barred because it also stated claims for account stated, open account, unjust enrichment, therefore subject to 6-year statute of limitation for contracts action pursuant to state statute, rather than the 4-year statute of limitation. The federal court rejected that argument and followed the Michigan law that the court looks at the true nature of the claims, not the label applied to them. The federal court noted that First of America Bank versus Thompson controlled the case. How that a claim for unjust enrichment was premised entirely on the underlying sales transaction for a vehicle. Thus, the 4-year statute of limitations of the UCC should apply to that claim. And so, deficiency actions following a repossession are governed by MCL 440.27251. That's clear, correct? This was deficiency. There was a deficiency after a repossession.
That's correct.
Okay, so tell me how that could not be governed by MCL 440.2725 paren 1. This is clearly what that is.
Well, again, Your Honor, if Your Honor applies the bar of any interest barring after the sale of the vehicle, Your Honor then applies or Your Honor then applies or finds that this is a transaction for the sale of goods within the definition of the UCC.
No, I didn't order that, counsel. I didn't say that's what I found either. I was just asking, based upon what Mr. Ivanchik's argument was, how was there interest that had continued, right? Because he argued in the alternative that if there, I don't even think he argued in the alternative. His argument was that there should not have been continued interest applied.
But Hardin v. AutoVest LLC also involved the purchase of a vehicle from a dealership or a seller, again, under a retail installment sales contract, a motor vehicle retail installment sales contract.
Okay.
Which again comes back to the application of the UCC. And so it's plaintiff's position that if this were a deficiency action in a motor vehicle retail installment sales contract, then certainly plaintiff would agree that any accrued interest would be barred, but this entire transaction is outside the scope of the UCC, including the accrual of interest, because this is a direct loan agreement, not one entered into by the parties for transaction for the sale of goods. And that would be plaintiff's response, Your Honor.
Counsel, well, this is very creative, right? It's very creative argument and lawyering. At the end of the day, there is a loan for a vehicle. That loan specified what remedies in the event there is default by the borrower. One of those was to repossess the vehicle and resell it. This is clearly a deficiency action. It appears to me, in reviewing both cases, that this is the same set of circumstances as the case on point that this court must follow. It's Michigan law, as well as MCL 440.2725(1). This is a deficiency action. Your client is trying to get made whole from the deficiency from what the vehicle was sold for and the balance that was owed on the loan. Now, I'm not going to get into why Mr. Cervello didn't continue to pay. I know there's an allegation of insurance improperly put on there. I don't know if that's really not before the court at this point, but the court does find this is a deficiency action and that the 4-year statute of limitations applies. And based upon the timing of the 4 years and the timing of the filing of this complaint, the court finds that it's outside that statute of limitation, and therefore the court's going to dismiss this matter with prejudice. The court's going to grant the defense motion for summary disposition. Mr. Vanchek, I apologize if you didn't argue or get to state too much that would allow you to bill accordingly. I don't know, but I was very clear with the position, and as it was supported by the law. And so Mr. Sasson, very, very creative lawyering, very, very good attempt, but
Thank you, Your Honor.
motion is granted.
Thank you. I will circulate an order to Mr. Sasson, I believe, and we'll submit it to the court for signature.
Okay, thank you.
Thank you, Your Honor. Thank you, counsel.
Have a good day.
You too, Your Honor. Thank you.
So let's go on the record in the matter of the state of Michigan versus Mason Tetri. 24380. And Detective, your name for the record, please.
Good afternoon, Your Honor. Detective Joseph Carr, Wyandotte Police Department.
All right, please raise your right hand. Do you solemnly swear from the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You may proceed on the warrant.
Your Honor, on April 7th, about 9:30 p.m., Officer Adam Grove reported that he observed a black Ford Fusion bearing the Ohio plate of Henry David X-ray 708 with a defective license plate lamp traveling southbound Biddle near Goddard at a speed greater than the posted speed limit. Officer Grove reported that he then conducted a traffic stop with the vehicle and made contact with the driver, later identified as the defendant, Mason Tetri. Officer Grove reported that he immediately observed a pair of rolled-up camouflage pants on the driver's side floorboard directly underneath the defendant, where the defendant was seated. The defendant was unable to produce any form of picture identification or proof of insurance for the vehicle. Officer Grove asked the defendant to exit the vehicle, at which time he complied and consented to a search of his person. Officer Grove, for officer safety, the defendant and a front seat passenger were secured in Officer Grove's vehicle and a second assisting patrol vehicle. Officer Grove reported that while speaking with the defendant, he was very evasive about narcotics or any contraband inside the vehicle. Officer Adam Grove noted that while speaking with Officer Tyler Grove about the vehicle and the stop, he then observed in plain view the handle of a pistol protruding from the pair of camouflage pants on the driver's side floorboard, directly where the defendant was seated. Per lien SOS, the defendant does not have a CPL. Officer Grove then placed the defendant under arrest, where he was conveyed to the station, booked and held. The recovered firearm was described as a loaded 9mm Springfield XDM Elite, which per lien is unregistered.
All right, upon examination of the pleading witness, I find the offense charged was committed. There's probable cause the defendant committed that offense. And counsel, your appearance, please.
Yes, Your Honor. Edward Holmberg on behalf of the defendant. Your Honor, for arraignment purposes, we stand mute, waive a formal reading. I have gone over the defense constitutional rights with them. We have no objection proceeding by Zoom.
All right, thank you. And Mr. Tetri, your name, please, for the record.
She said, stand up, your name.
Mason Tetri.
All right, the court's going to waive the formal reading. So you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you had an opportunity to speak to an attorney today, correct?
Yeah.
Yes?
Yes, Your Honor.
All right. And you also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. And you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes, Your Honor.
The court has also signed a petition order for court-appointed attorney for felony matters. We're going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference April 19th at 9 a.m. at the 28th District Court. And as to bond counsel.
Your Honor, he is employed at a Below's restaurant in Toledo. It's where he's a resident as well. He states that he has no prior criminal history or is on parole, probation at this time. It is a gun crime, I understand that, but it's a non-assaultive offense. We would ask for a personal bond in this matter.
And sir, where is it you work?
It's in Toledo. It's a Lebanese restaurant.
And how long have you worked there?
About 2 years.
All right. And have you ever failed to appear in court before, sir?
Never.
Not on bond in any other jurisdiction?
What you said? Ask her.
Are you on bond? You're not on bond, correct? Right now?
No, ma'am. No, Your Honor.
Okay. And how do you know Ms. Jackson?
Miss Jackson, who was in the car?
Yes.
I just met her that day. I actually don't have any.
Or somewhere else? Did you meet her in Michigan or somewhere else?
No, I met her on online.
Okay, well. Okay. So does she live in Ohio or does she live in Michigan?
I think she lives in Wyandotte.
Okay. All right, and Detective Esteban?
Your Honor, I do have some concerns regarding the defendant's next court appearance, as he does show an address in Ohio, and he does seem to work in Ohio. So I'm going to recommend a $500 cash bond, and in addition to a GPS tether to reassure his next court appearance.
All right, here's what the court's going to order. Due to the fact that you live out of state, sir, the court wants to ensure you're going to be reappearing in court. One way to effectuate that is to have you post a $5,000 10% bond. Also, for the safety of the public, the court's going to also order no weapons or firearms. Do you have any of those at your home, sir?
No, ma'am.
All right, you're not to possess or consume any alcohol or drugs unless prescribed. And the court's going to also order a GPS tether. Sir, do you anticipate posting that bond today?
Yes.
Okay. Do you have an extra $182? If you do, then you can have your tether from a third-party agency other than the Wayne County Jail.
And now, would that happen today?
Yes.
Yes, I have 100. I have an extra.
Okay, I'm going to make that note on here as well.
Your Honor, can I have the date of the PCC, please?
April 19th at 9 a.m. at the 28th District Court.
Thank you.
Thank you, Your Honor.
All right, and that will be all, sir. Thank you. Have a good day.
Thank you, Your Honor.
All right, we are on the record in the matter of the state of Michigan versus Thomas Tubb, 24377. And Detective, your name for the record, please.
Detective Joseph Carr, Wyandotte Police Department, Your Honor, on information and belief.
All right, thank you. And you are still under oath, and you may
That's
proceed.
correct. Your Honor, on April 7th, 2024, I'm sorry. Yeah, I'm sorry, April 7th, 2024, about 1:24 in the morning, Officer Grote observed the blue Ford Fusion traveling northbound on Biddle near Sullivan in the left lane. Officer Grote reported that the vehicle spontaneously changed lanes several times without using the turn signal. He also observed the vehicle swaying between the indicator lines and crossed into the Biddle parking lane multiple times. Officer Grote, Adam Grote, initiated a traffic stop in the vehicle and made contact with the driver, later identified as Thomas Ray Tubb. Officer Grote reported he immediately smelled a strong odor of alcohol and alcoholic intoxicants coming from the defendant. The defendant was reported to heavily slur speech. His face was flushed and exhibited a blank stare and watery eyes, and admitted to consuming a couple of beers at the Dock Pub. The defendant refused any standard field sobriety tests, at which time Officer Grote asked him to exit the car, where he was going to be placed under arrest for OWI. Defendant refused to step out of the vehicle, began rolling up his sleeves in an indicator that he wanted to fight officers. Officer Grote radioed for additional units for backup. Once backup arrived, Officer Grote provided the defendant another opportunity to exit the vehicle, at which time the defendant began to roll up the big window to avoid arrest. The door of the vehicle was opened, and the defendant was seen reaching for the ignition and keys, attempting to flee the scene. The defendant fought with officers, but he was subsequently placed under arrest, taken to the station where he was read his PBT rights, chemical test rights, and agreed to a breath test, which was a result of 0.18, and the second test was 0.18 as well. Lean showed that the defendant has multiple prior convictions for OWI, Your Honor.
All right, thank you. Upon examination of the complaining witness, the court, I do find that the offenses charged were committed, and there's probable cause for the defendant committed those offenses. And sir, counsel, your appearance, please, for the record.
Yes, Your Honor. Edward Holmberg on behalf of the defendant. For arraignment purposes, we stand mute. We have a formal reading. I have gone over the defense constitutional rights with them. We have no objection proceeding by Zoom.
All right, thank you. Sir, your name for the record, please.
I'm Thomas Ray Tubb.
All right, thank you. And the court will waive the formal reading. Sir, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you had an opportunity to speak to an attorney today, correct?
Yes, the one here, yes.
Okay. And you also understand that and the court has also signed the order for a court-appointed attorney for felony matters. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes, ma'am.
All right. And the court will enter a plea of not guilty, and you may have scheduled this matter for probable cause conference on April 19th at 9 a.m. at the 28th District Court. And as to bond counsel.
Yeah, he is retired from Ford Motor Company, does live in the city of Lincoln Park. We would ask for a personal bond with an alcohol tether.
And sir, where is it that you live in Lincoln Park and you're retired? Do you do anything else? Do you volunteer anywhere? Do you have a part-time job?
I Grubhub, deliver foods, a few days out of the week, especially in the winter time. Give me something to do. That's about it, Your Honor.
Have you ever failed to appear in court before, sir?
No, ma'am. No.
Are you out on bond in any jurisdiction?
No, ma'am.
All right, Detective Carr, as to bond.
And I would request a $500 cash bond in addition to the alcohol GPS tether, Your Honor.
And the court would agree with that. Given that this is your third offense, sir, and the high level that's alleged, the court does find as a way to help maintain your abstinence from alcohol and to ensure your appearance, as this is a felony, the court's going to order $5,000 10% bond. You're not to be released without alcohol tethered to the Wayne County Jail. Not to possess or consume any alcohol or drugs unless prescribed.
Okay.
All right, thank you. Have a good day.
Thank you, Your Honor.
Thank you, guys.
All right, thank you. All right, we are going on the record in the matter of the City of Wyandotte versus Brandy Jack, 24381 and 24378. And counsel?
Yes, Your Honor.
Your
Edward Holmberg.
please.
Yes, Your Honor. Edward Holmberg on behalf of the defendant. Your Honor, for arraignment purposes, we would stand mute, waive a formal reading. I have gone over the defense constitutional rights with it. We have no objection to proceeding by Zoom.
All right, thank you. Ma'am, your name for the record, please.
Brandy Lynette Jack.
All right, the court's going to waive the formal reading, enter a plea of not guilty on your behalf for both of these matters. Schedule these matters for pretrial April 24th at 10:15 a.m. And counsel as to bond.
Your Honor, she is a member. I don't want to mispronounce the Indian tribe, the Indian nation that she's a member of. She is seeking help through them. She is homeless because she no longer lives with her mother, but does receive a per capita sum from the nation's casino. We would ask that it's a non-assaultive crime that she be given a personal bond with no alcohol consumption.
Great. Ma'am, what is the name of the tribe that you belong to?
Kagan Band of Potawatomi Indians.
I'm sorry, what brand is the Potawatomi?
Yes.
I'm sorry, I didn't hear the first part. You said what brand?
Pokagan.
Pokagan?
Pokagan Band of Potawatomi Indians.
Okay, I apologize. When you're starting to talk, it's not picking everything up that you're saying.
No, I don't have teeth, so it's hard for me to articulate.
Okay, that's okay. Well, Mr. Holmberg didn't grow up here in the US, so he probably would have learned how to pronounce that properly. I don't know. All right. And so, ma'am, are you out on bond in any other jurisdiction?
No. I have a
It
drinking
shows that
problem.
you last lived. It shows that you last lived in Dowagiac. How did you end up over this way?
I came to visit my mom because she's sick.
And where does your mom live?
Allen Park.
Okay, so when's the last time you were with your mom?
I talked to her this morning.
No, when's the last time you were with your mom?
Probably about a month ago.
So you came down to see your mom. Oh, yes. Well, you have an issue out of Allen Park that you have to take care of.
Yes.
For public peace and larceny, which is the same, similar charges that you have here. Okay, well, it's alleged that you are at a .228, and the fact, and here's the other concern the court has, that you have pending matters in Allen Park, and that you don't have anywhere that we can find you if you don't show up. The court's going to order a $5,000, 10% bond on each matter. In the event bond is posted, you're not to be released without a GPS and alcohol tethered through the Wayne County Jail. You're not to possess or consume any alcohol or drugs that are not prescribed. Anything else?
No, Your Honor. Thank you very much.
Okay, thank you. Have a good day. All right, thank you, Mr. Holmberg. All right, off the record.
Are you kidding me? Oh my God. You have got to be kidding me. What is going on today? This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself something.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what? Let's bring people to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am, can you hear it? Okay.
I have no patience for that. But trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.